Good afternoon, everyone. My name is Dresden Ferrand. I'm the new Vice President of Chapter Development for IEC, and I started last week. I'm really excited to be able to say hello to you all, and I look forward to meeting you all in the future. I would like to welcome you to the IEC National Webinar Series. Today's webinar is titled Legal Concerns in Managing a Chapter. Please note that we will be recording this session, and it will be available to you on the IEC website under the Training tab and Continuing Education if you'd like to refer back to it or have someone else in your office who would like to review it. All attendees are muted for the duration of the call. We encourage you to send in your questions as you think of them by typing them into the chat section on the right side of the screen. Our speaker today will be reviewing your questions in real time and answer them accordingly to his presentation and time. Today's speaker will be Phillip Russell. We're very excited to have him today. Phillip is a practical labor and employment lawyer with Ogletree Deakins in Tampa, Florida. He represents businesses in a wide range of labor and employment law matters, including workplace safety and health, traditional labor relations, unfair competition and trade secret litigation, employment litigation defense, and advising and counseling employers on workplace legal compliance issues. Phillip represents clients in the construction, staffing, technology, manufacturing, and banking industries. Ladies and gentlemen, please welcome Phillip Russell.
Good afternoon, Dresden. Thank you very much. Tim, Lisa, and everybody else at the IEC National Office. I want to thank you for having me involved in the IEC webinar series. Just to confirm, audio okay, Dresden? We doing all right with that?
Yes, you are doing great.
Excellent. Okay, so today what we're going to talk about, legal concerns in managing a chapter. Those of you who have heard me speak either at the National Convention or the other national meetings that we've had and I've attended throughout the years, legislation, leadership, et cetera, know that I like to be interactive with my audiences. So my first disclaimer of the day is webinars are not usually my strength because I'm talking to a computer screen. So I'm going to challenge you all. I think I heard 30-something folks are calling in today for the webinar. I'm going to challenge you all. If you're individual, that's fine. If you're in groups, send me at least one question. And send them as we go. So that way when I look at the questions as they come in, then I will have some interaction that I can have as we go through this. I think, frankly, I'm a better teacher, a better educator, better trainer whenever I've got some interaction. So that's how we're going to do it today. So hopefully you all, if you were in a room with me, hopefully right now I'd be getting some head nods up and down saying that, yes, you will take the challenge and try and throw some questions my way. Now, a word about the topic, legal concerns in managing a chapter. Well, what would a labor and employment lawyer know about that? And that's a great question. But I fortunately, over the many years, had the opportunity, in addition to my labor and employment practice, I've had a lot of opportunities to advise nonprofit organizations here locally, either sometimes on a paid basis, but sometimes I've done it as part of my pro bono community service. But I've also, over the years, had opportunity to serve some IEC chapters, primarily the IEC chapter here in my hometown of Tampa with a Florida Gulf Coast chapter. So, you know, and I want to give a shout out to those guys. I actually don't have a list, so I don't know who's on the phone, or if they're on the phone. I think they're in Tallahassee today for the legislative day, which is great because I saw a picture of them a few minutes ago. So if I've got those folks on the phone, shout out to my home chapter and then my other friends around the country. So I'm going to be speaking to you today from some points of experience and having advised some chapters, and then just, of course, my longtime experience in representing a lot of the members in employment and labor law matters over the years. And thank you to you all, and I just cannot tell you what gratitude I always carry in my heart for my friends at the IEC. So with that said, I'm going to hopefully also not mess up the technology, but we'll see what we can do with it. So let's jump in. What are we going to talk about today? We're going to go over these topics. We're going to talk about chapter organization and governance. We're going to talk about those antitrust issues. They pop up all the time. And surprisingly, you know, we've had some issues over the years in which you're going to have to take a look at what you can and cannot do, because what is an industry association. What is a chapter? What is an IEC chapter? Well, at its base, it is a group of folks that are in the same industry that are supposed to be competing against each other. In fact, do compete against each other, but they're also trying to share information and improve the industry. And there sometimes ends up being an issue with that, because there are some things you can do that you cannot do to improve your industry if it involves things that might negatively impact competition. So we'll talk about that. Talk about membership restrictions today as well. That's a topic that comes up from time to time in terms of what your membership restrictions can be. Can you limit, can you exclude members? Can you put limitations on members? Those sorts of issues. We'll talk some briefly about shared worker programs, D&O liability insurance, and of course, back to my more of my comfort zone of employment law compliance. But the interesting thing is many of the issues that really face your chapters in terms of legal liability and compliance actually come out of employment law compliance areas. And there have been a number of chapters over the years that have actually had employment issues of their own. So we'll talk about a few of those items today as well. Hopefully today, at the end of this hour, you'll have some action items. So the second thing I'll challenge you to do, in addition to throwing a question or two my way, is writing down at least one thing that you're going to do, one action item from today. I think sometimes in webinars and seminars, we speakers think, oh, I gave these guys 10 things to do. Nobody's ever going to do 10 things. I've learned that over the years in training, and what I think that if I could just challenge you this, I promise you I will give you 10 things, you pick one. And if you can do that, then I think you can have something that'll help your chapters. All right, now let's jump into the law. First area we're going to start is going to be the Internal Revenue Code, that big behemoth of a law that has created and empowers the Internal Revenue Service to go out and do what it does. Under the Internal Revenue Code, we all are 501c6 organizations, which means we are tax exempt. We are not taxed by the federal government for income. Now, that doesn't mean that we should not have income that exceeds expenses, because if we had it the other way around, expenses exceeding income, we're not going to be in business very long. But what it does mean is it means certain things. It means that you have to hit the 7-point checklist in order to not be taxed on income at the end of your year, at the end of your fiscal year. When you close out the books, if there's any money left over, and that net income, which would otherwise be subject to tax, would not be subject to tax if we do these things. Now, there are 7 of them. I'm going to go over the list now. I'm going to highlight a few of them on the next few slides. But just beginning here with number 1, this is an association of people with common business interests, persons. The persons could also mean corporations, obviously. And its purpose is to promote the common business interests. And we'll talk about what those common business interests can be. It's a membership organization, which means that you must have members. Duh. Thank you very much. Sometimes the law is not that complicated. In this area, it's not. We have members. We must then charge dues. We have income coming in from the members. We provide benefits and services to the members. It is organized not for profit. We'll talk about that in a little more detail as well, but essentially that means that no individual company or person gets to take home any dividends or dividend-like payments from the operations of the chapter. No part of the net earnings may inure to the benefit of a private individual. It's essentially the same thing, but the word inure is thrown in there because lawyers and accountants like that word to essentially say nothing can get to you indirectly. So it's not only direct payments, it's indirect payments. Benefits must essentially inure or go to everyone in the organization according to their membership status. 5th point, its activities must be directed to the improvement of business conditions in one or more lines of business, as opposed to performing services for particular companies or persons. And essentially, I think all IEC chapters, really do this and do it very well. And that would be things such as providing legislative advocacy, providing training programs like our apprenticeship programs, providing educational programs like today. Those are all things that will improve the business conditions across the board as opposed to helping individual or particular companies. 6th point, primary activity that does not consist of performing a particular service for individuals. That really, I think, is sort of an extension of number 5. And then number 7, the purpose must not be to engage in a regular business of a kind ordinarily carried out for profit. Not going to be an issue, I think, with our IEC chapters. So let's talk about dues for a minute. Any income that's derived from performance of the functions or from substantially regulated activities could be treated as membership support. That counts as dues. So, or that counts as proper income. It's not against the rules for a chapter to be able to generate revenue, to generate income from, various sources, but the primary source really does need to be from dues. And that needs to be and the reason why is because go back to what 501c6 requires, that you've got to show that it is an industry association for the betterment of its members to support general growth or general improvement of industry conditions, and you do that by having members. Contrast that with a for-profit company that might have shareholders. Essentially, members become sort of a pseudo shareholder when you take a look at the organization from that perspective. Contributions or gifts from the general public can be treated as membership support, and then unrelated income should be excluded. When you take a look at, receiving, for example, here, professional association receiving fees from non-members for a training program, that's okay too. As long as the primary revenue is coming from dues, then you're okay to make some money on the side, so to speak, by charging if a particular chapter set up a webinar series or seminar series and you charge for attendance and you're covering the cost. Well, you can also have some bottom line revenue coming in as well. So they contribute to your chapter operations. Nonprofit, no shares issued out to anyone that carries the right to dividends. So incorporation occurs, and we'll go through this in a moment on governance, but incorporation of a business entity is a state law matter. It's not a federal law matter. So right now, I'm just taking a quick look at what's the federal law with regard to the non-exempt 501c6 status. In a moment, we're going to turn the page and take a look at state law. But what state law will govern when it comes to the organization, whether you're an LLC or an Inc., an incorporated or corporation, and what kind you are from there, that really is a matter of creator of state law. So I know we have folks on the phone today on the call from many different states. I'm going to use, I think, Delaware as our example state today because it's the one that in corporate law tends to be looked at the most, but there might be some nuanced issues in your own state. So word of the wise there is make sure that you are checking your local state's statutes when it comes to the organization. But the one thing that has to happen from the federal law perspective is nobody gets stock in the entity that has a right to dividends. And back to that, no inurement to any individual or company requirement. And what is an improper inurement or improper benefit that indirectly flows to someone? And that is when it goes beyond the logical flow of the organization's performance of its exempt functions. Frankly, I wanted to put that in there. I wanted to put in the memo, the general counsel memo in that statement, but I have not been able to come up with an example for you. So I think the good news there is that it's probably not a big risk as long as we are putting the right controls in place. Now let's talk about state law. The corporate statutes, regulations typically are all driven by state law. The two main documents you're going to have will be your articles of incorporation, but the main document, the big one, is the third bullet point there, the bylaws. I've been involved in either drafting or reviewing bylaws from time to time for various chapters, and I will tell you that one big issue that I frequently see is the failure to review the bylaws on a periodic basis. Now, I'm not sure that you need to do it every single year, although I think that's the wisest. So I'm going to put in here at least every other year, at least biannually, dust off the bylaws, take a look at them, have your board look at them, and have your attorney, have your counsel look at them, and see whether or not there's anything that needs to be updated. And you're going to look at it from several perspectives. You obviously want to know whether or not there have been any changes in the law that might impact the bylaws. But there's not a lot of changes that often occur that would really drive your changes. Your primary focus is going to be your operations. Have you operationally fulfilled what you said you would do in the bylaws? Are there areas where you fell short? And I think one good practice to do with bylaws is, frankly, is to have them at all meetings just as a reference point, because sometimes you want to make a note on the bylaws that something needs to be reviewed, something needs to be changed, or something needs to be updated. You may not, if you wait and do that, instead of doing it as you go, but you just wait on once every 6 months or once every 9 months, once every year, year and a half, you might not be able to refresh your recollection as to what it is you thought needed to be addressed. So if you haven't written down yet, one of the items for your to-do, here's an easy one. Pull out those bylaws, dust them off. All right, so thank you for whoever sent in the question. I do have the first one of the day. We'll see what I can do with it. Question is, would you recommend the IEC chapters consider having a 501c3 as well as a 501c6 to keep the accounting separate? Well, a 501c3 is a nonprofit. That is is more of a charitable function. So if you have set up a foundation and it is fulfilling its charitable functions, then I think that would be okay. I'm going to recommend that you talk to your accountant before doing so, because accountants have a lot to say when it comes to the selection of which internal revenue code you are going to use for a various purpose. But what I recommend I don't know, because I don't know what your goal is. If your goal is to just run as a traditional IEC chapter, then no, the 501c6 is sufficient for the purposes we've already outlined. If your purposes are going to go into the charitable world and you want to maintain that as a separate operation, then you would want to talk to your accountant about doing a 501c3. So hopefully that took care of that issue. Now I want to talk about your board of directors, and thank you for whoever sent in the question. Board of directors. Let's talk about the legal issues involved with your board of directors. And I think this goes really to the heart of what is your organization, how is it formed, and what are the roles and responsibilities of the board? Because as you don't have shareholders, you don't have stockholders, you've got board members that are elected by your members. And you all know basically how the chapters operate, but let's take a look at what those legal issues could be. And you'll see here, we'll talk about responsibilities, fiduciary duties, ways to mitigate liability and exposure, D&O insurance, we'll cover that topic, and then just some operational issues like agendas, your board structure, conflicts and related person transactions, and some board performance and self-evaluation. Now, some of these concepts, I will tell you, relate also to big public companies. And you might think, well, you're a small chapter, you're not like a big public company. And in many ways, you're different. But when it comes to operational issues like these, I've tried to create a list where I think that these issues would also be applicable to chapters. So let's take a look at first one here. Under state law, under responsibilities, the board is responsible for the direction and management of the corporation. Pretty simple, right? They're the folks that are in charge. But the role is oversight of management. And let's be clear about that, because typically the board is going to delegate day-to-day management to the executive director and his or her management team. It is unusual and risky, I will tell you this, for the board to circumvent the executive director and the management team and deal directly with employees. I'm going to let that sink in for a minute, because I see this issue pop up, because you might have an activist board member, and that's fine, because we want folks serving on the board who really want to be energetic and enthusiastic about the mission, about the purpose of the organization, about its goals, and whether it's achieving things, and whether there are any problems. But understand this, you need to go through the executive director and the management team instead of dealing directly. In fact, frankly, the best advice I got for board members is to not even go to any other senior management person, but to go to the executive director unless or until the executive director has delegated some responsibility to another senior management person of the chapter that would then allow perhaps some direct communication. Now, the reason I say all this is because and if there are any board members on the call, I would say directly to the board member, let's stay in your lane. Your job is oversight of management. It is not management. You are not running the chapter. You are overseeing the chapter, much like you would have a board of directors of a public company representing the stakeholders or the shareholders. You are representing the members and making sure that the hired professional staff is staying on task. But it is not your job to run the chapter. That falls in their lane. So I would say to them, stay in your lane. And be aware that the more you get involved, and if you want a horror story out of this, I could tell you several, where individual directors who interjected themselves too deeply into the operation of a nonprofit And I will tell you this to be clear, I'm not thinking of an IEC chapter when this occurred. I'm thinking of another nonprofit, but the board member was named individually in a lawsuit involving the termination of an employee. And what happened is that board member interjected herself in that case way too deeply in the operations of the organization instead of staying in her lane. So task number 2 here, stay in your lane. All right, let's move on to next slide. Key board responsibilities: selecting, evaluating, compensating as needed, and if needed sometimes, and this happens from time to time, replacing the ED. Providing guidance on strategy and long-term plans, executive compensation, more managing performance. And these are really sort of the details of what it means to sit in your, or to stay in your lane of oversight of management. You're looking at, you look at the executive director, you look at overall corporate or overall chapter performance, and planning, involved in planning. By all means, be involved in the planning. Capital allocations, major expenditures, you certainly should be reviewing to make sure that we are we're spending money appropriately, we're investing appropriately. We are organizations with limited resources, just like the businesses that the board members are in on their own. We are running a business, and we need to make sure we put in proper financial controls, auditing and reporting and disclosure as appropriate. Overseeing the risk management, ethics, and legal compliance. Those are all responsibilities that fall to the board. Now, the day-to-day compliance obviously is up to the executive director and senior management, but the board's role there is to make sure, is to be this check, is to be the validation that things are going as they should and done appropriately. Now, what are the fiduciary duties? I'm going to make some references here to Delaware law, but again, Delaware law is kind of the model corporate law. Most states follow either Delaware law or close to it, so check your state law for some variations. But generally speaking, the fiduciary duties of the members of the board require that directors discharge their duties in good faith with the care of an ordinarily prudent person under similar circumstances and in a manner they reasonably believe to be in the best interest of the corporation. Now, that means not the best interest of his or her own business, but in the best interest of the chapter. And that's important because sometimes I think our board members may feel inclined to take a look at a particular issue or policy or service or benefit and forget the fact that now that they are serving on our board, they are representing the members, not their own individual company. I think that from time to time we might have to, as executive directors, may have to be in the position of reminding someone exactly what their role is. Could be uncomfortable, of course, but that's where you have, that's why you got to step up and show that leadership. So there's really 2 components to the fiduciary duty that directors owe to the chapter. Number 1, the duty of care. Number 2, duty of loyalty. We'll go into this a little bit further and see what that means. Duty of care. Duty of care means that the directors must take, or the board members, and here when I say directors, it's the board of directors or board members, same term, but must take reasonable steps to become informed prior to making a decision. Now, I underlined reasonable steps. I probably should have underlined informed, because the key point here is that it's up to the members to make sure they have, or up to the board members to make sure they have information they need before they make a decision. If they don't have sufficient information, the obligation is don't make a decision. Now, the obligation on the chapter, on the ED, is to make sure that your board members have the information they need to make decisions. And that is something that can be done and handled reasonably well through the meeting process, through making sure that the agenda for the board meetings have attached to the agenda, that you have the supporting documents, whether it's spreadsheets, reports, analyses, whatever other information members may need in order to vote on a particular item. They must act on an informed basis and give careful consideration to all material facts and circumstances. It should reflect a thorough, careful, and deliberate process. And of course, the greater the decision, the greater the magnitude of the issue, the higher the level of responsibility and the duty of care would arise. The directors discuss reasonable or potential alternatives. A great question that I, as a director and sitting on board, like to ask from time to time is, well, what else could we do? If not this option, what else could you recommend? And what that does, what I find is that challenges the executive staff, and in this case, it would challenge the ED to say, to come up with an alternative. So whenever there is an issue on which there needs to be a proposal, as opposed to saying you have choice A, and that's it, we ruled out everything else for you. No, that's not the proper way. And you EDs on the call, I would say a better approach is, here's choice A, here's choice B, maybe even choice C. I like A. That's a better, more appropriate way to go about to allow the directors to fulfill their duty of care. The more significant, of course, the subject matter, higher level responsibility. Minute taking by the secretary, chapter secretary, or secretary of the board, or even the ED, whoever's taking notes, but notes and taking minutes, don't look at that as just an administrative hassle or nightmare. That really could be an important issue. And I will tell you, when it comes to deciding whether or not to, what kind of tables to buy for your training room, that issue is not nearly as significant as to whether to launch a massive new training program that may cost tens of thousands of dollars. You can look at those two decisions separately. But the greater, bigger decision needs to be a higher level of documentation in the file for how the decision was made. Now, duty of loyalty, taking a look at that, directors must act in a way they reasonably believe to be in the best interest of the chapter. Now, that is an affirmative duty to protect the interest of the chapter. That is, and again, when you see the word corporation here, you can just read in the word chapter. But there's an obligation to refrain from conduct that would hurt the chapter or its members or to deprive them of a benefit. And they cannot use their position for personal gain or advantage. And that really is this duty of loyalty issue here, I think, really does mesh nicely with the antitrust obligation of not using the chapter for personal gain to either promote his or her own business, or worse, really, to exclude other businesses from participating in the benefits of the chapter. That could raise all sorts of issues, and even under the antitrust laws, there actually are potential criminal claims that could be raised. So, but the mere existence of a personal benefit alone is not going to necessarily stop the board member from serving. It could be a matter of disclosure, and if there is a proper disclosure to the board. I can't give you an example here. Maybe somebody on the call has an example to discuss, but I've never had a conflict of interest with one of the IEC chapters. I have had conflicts of interest with other kinds of operations, but haven't had one, and I think that's a good thing. And I like and respect the integrity we seem to be having. All right. So what's the realm of decision-making authority you have? Well, you have a tremendous amount of authority under what's called the business judgment rule. And again, I'm speaking to the directors here, that under the law, the decisions that the board makes are generally protected by the business judgment rule, which says there is a rebuttable evidentiary presumption that you made a good decision. Now, and what that means is that a court later on cannot substitute its own judgment and say, well, that was a bad decision. No, the only real breach here of duty as a director would be if you breach the duty of care, which we just discussed, or the duty of loyalty. The fact that the decision may be boneheaded in the eyes of a judge later on down the road does not state a legal claim. And this is a very important thing. Business judgment rule is really hugely critical. I don't know if you've ever even heard of it, but what it does is it does allow directors to have some umbrella of protection under the law to be able to make decisions. And as long as they are not self-dealing and violating that duty of loyalty, and as long as they are exercising their duty of care, the things we talked about, being informed, making decisions, considering alternatives, then they are going to be insulated. Okay, I got another question, and this one kind of makes me laugh. I'm not quite to the D&O insurance section yet, but the question is, how much should I be paying for D&O insurance? Well, that's a funny question. Not only am I not an insurance guy, being a lawyer, but I have no idea how much you should be paying. So I'm going to just leave that answer at that. I would hope that you would be able to get good guidance from an insurance broker on that. If not, I can refer you to someone, but I have no idea what you should be paying for that. But thanks for the question. You at least met that obligation. All right, reliance on others. It is okay for board members to rely in good faith on on documents and information from the chapter. Officers of the chapter certainly should be reporting to the board. The board also can get lawyers, financial advisors, accountants, et cetera, to come in and make reports, and they should do that from time to time. So it's not just a matter of being able to legally rely upon the chapter officers, but it's also reaching out to others from time to time. What are the protections from liability for the directors? Well, you have the certificate of incorporation, exculpatory provisions that could go into your initial. Now, certificate of incorporation is another word for articles of incorporation, and then also put it into your bylaws. And then you might also have some indemnification agreements from time to time with particular executives, and I've actually seen that quite often. And then under D&O insurance, maintaining insurance. So there are legal provisions, exculpatory provisions, indemnification, and then also insurance that would really cover. Now, I want to actually talk right now about EDs, because I've talked quite a bit about board members, so I want to make sure that you understand what their roles and responsibilities are. But as the executive director, let's touch upon this, because it really does come into the O part of D&O insurance. A lot of these same concepts I'm talking about when it comes to the protection of the executive could be used for, or protection of the board members could be used for the protection of the officers or the ED. Because we want our EDs, of course, and I'm sure I have a lot of heads nodding right now, to be able to make decisions and not worry about being sued by a board member or a member of the chapter or anyone else for carrying out his or her duties. And of course, I'm sure that's what's driving the question. Now, some of these items may be covered by employment practices liability insurance, and I'll talk about that in a moment. But when it comes to what are staying in your lane, I've outlined the lane pretty clearly for what the board members are. What's left is really up to the executive. It's up to the ED. Unless the board has reserved some area of authority and said, no, ED, you don't do that. We're going to do this for some reason. Then the ED is the chief executive officer of the chapter. The ED is the person charged with running the chapter, running the organization, carrying out the plans and strategies. What legally is their obligation? They actually also do have a duty of care and a duty of loyalty, and cannot be doing similar things to what I've outlined earlier with self-dealing without disclosure and discussion, and then also a duty of care. What is the remedy for the board if the executive director fails to do those things? Well, of course, you can always change executive directors and have them, help them on with the next chapter in their life. Hopefully that doesn't happen, but I do know that from time to time with chapters, that has happened. I've been involved in several transitions, and unfortunately sometimes that's just where you've got to go. Mitigation of liability, having the right people look at right issues with the right process, key practices, a few ideas and thoughts here on the slides. And by the way, these slides, we're going to email them all out to you or distribute them in some way. I'm not quite sure I was right about email, but they will be in your hands, so you can come back to these as your checklist checklist later on. D&O insurance, let's talk about this. Who is the insured under a D&O insurance policy? Well, that's all past, present, and future directors and officers. There's the D&O part. What is a wrongful act? Well, these are things that when you talk about an error, a misstatement, misleading statement, an act, it's either neglect, or some other, something they did or failed to do that resulted in a loss to the chapter. And of course, loss being some sort of claim for damages, judgment, et cetera, about the operation of the chapter. And so the interesting issue here is, D&O, well, who does it protect? Well, it would protect everyone that I've spoken about so far. It would protect your board in their decision-making authority, and it also protects your officers in what they do. Now, there are some things that are not covered under D&O, and this graph actually shows a few things and about how the coverages work. I'm going to qualify this a little bit and just say that I am not an insurance coverage lawyer, nor am I an insurance broker, so feel free to fact check me on these things. But from a legal perspective, the one area that seems to not be covered by D&O more often than not are decisions made on employment. Now, as I've already said, if the directors or the board members are staying in their lane and not getting involved in employment decisions, then typically what you're going to see is the ED may be someone who is named as a defendant in an employment lawsuit. Well, you should be comforted by at least knowing this. 99% of the laws and employment laws don't have personal liability or personal exposure under the statutes for any employment decisions that are made by an organization. So you are highly, highly, highly unlikely to ever be named in an employment lawsuit. But if you are, then there is typically going to be coverage for you under the EPLI. But again, that's a coverage issue that may depend upon your particular policy. So when another action item is dust out your D&O policy, dust out your EPLI policy, and ask these questions of what happens in employment lawsuits, because I think that is really where I've seen most of the issues. If a member were to sue, for example, there's no individual personal liability for the most part for what you're doing as an executive director. And in terms of a board member, well, you've got the benefit of the protection of the laws with the exculpatory provisions and the way that the law works in the business judgment rule. But of course, you want somebody to pay the legal bills, and that's where D&O insurance comes into play. All right, board agenda. What you want to do on a board agenda is setting the agenda and almost having an agenda and sticking with the agenda. Those are all items that I think are just best practices. It allows the board to manage its time, deal with issues that are critical to be dealt with, and then also committees. Some chapters I know are not quite big enough or don't really want to set up board committees, and that's fine too. But I think that probably the most efficient operation, the best way to really stay in compliance in some areas, especially meeting your duty of care, is to have some board committees. That might consist of a finance committee, an executive committee, a membership committee. And those are those are just a few of the examples that I've seen, an apprenticeship committee at various chapters around the country. But you may want to have those committees. And in terms of the agendas, what does an agenda do? Well, an agenda is not just there to be an administrative nightmare. I mean, sometimes I know keeping up with the agenda and keeping up with minutes tends to be a hassle, but it is there to show that the ED, as him or herself fulfilled his or her duties, but it's also there for protection on the board so that members can see at any time that you have fulfilled your duties and you haven't violated that duty of care and that duty of loyalty. All right, board structure and process. Your corporate governance guidelines and principles in your bylaws, that's where you describe how the board is structured. That's where you deal with any particular issues and setting up in the bylaws. And you put out in the bylaws as well, you include in there, and this is your checklist, by the way. Those of you who decided that, well, I'm going to dust out my bylaws and take a look, well, see if you have these items in there. Director qualifications, standards, what their responsibilities are, access to senior management, director compensation. Oh, there's no stock ownership here, so let's forget that part. That would apply to outside, so ignore the stock ownership part there. And then typically also addresses things at the bottom like the committee structure, director resignation, what happens if someone needs to roll off the board. Term limits are fine, you can do those. And a lot of chapters actually have not just term limits, but also acting or immediate past chairs. And what that does is that puts you in a position of having some overlap so that you don't lose some momentum. Conflicts and related transactions, conflicts, directors must disclose these, any potential conflicts. And this is where, if any, and I can't think of a good example, but if there were any situation in which a member or board member's business was getting some tremendous big benefit from the chapter, different than anyone else, well, that sure would need to be disclosed openly and some determination made as to whether or not that was something that you wanted to go forward with. Orientation and continuing education. I'm a big fan of board orientation. I'm a big fan of continuing education, not only in advising folks about how to advise directors on what their roles and responsibilities are, but also just reminding them. So I personally like to serve on boards that do that provide a very good orientation, and that also just at least once a year will say, hey, this is a reminder of what your roles and responsibilities are. Now, what I like to see where I'd like to see that originated is not necessarily from the ED, but perhaps from the board chair or somebody that is in charge of board development. I serve on the board development committee right now for one of my nonprofits, and I like what we do there. So again, talk about your task list and things you may want to consider. If you wanted to really make a difference, if you're having operational issues with your board, you may want to consider this as your first step. to go out and to have someone do an orientation for your board as to what their roles and responsibilities are, so that they can better govern themselves. Sometimes I find that, you know, these are men and women that are out running their own businesses and then come in on a part-time voluntary basis, serve on the board, and maybe they just don't understand that it doesn't operate, the chapter doesn't operate as his or her business does. We have to run it differently. So it may require some orientation and education. So that's another action item you may want to consider. And then, of course, self-evaluation, I think, is another thing that, you know, as I heard recently, you know, if you, well, as we've all heard, if you're not growing, you're dying. And I think that's true of all organizations, and I think that's true of boards, and you want a vibrant board. I've been involved in, you know, in our chapter here in Tampa Bay for, gosh, 12, 14 years. I think it's getting up there, and, you know, I'm honored and grateful for them. And I'll tell you, they've amazed me, because they have had succession after succession with great leadership on the board. And of course, with Raina in the last 10 years, I think, goodness, Raina's done a remarkable job as the ED. Before Raina, we went through some tough times and tough changes, but all through it, I saw tremendous leadership and overlap. And those folks, I think one of the things, and I don't know if they even do it on a formal basis, so I don't want to be speaking out of turn, but I know that they are constantly trying to improve what they do as a board. So that's another item for you, is perhaps to get the board to do an evaluation of how they think they're doing, and whether or not they're managing things well, whether or not they need to add on any other board members. Is there somebody else that they think they need to be involved with? Okay, I'm going to go through, I'm happy to have covered those issues because I know that they do come up. I'm going to cover antitrust. I'm going to cover it a little bit more quickly, but here's the bottom line on antitrust, is that the whole goal of the Sherman Antitrust Act is to encourage competition. It is to make sure that competition maximizes efficiency, distribution of economic resources, innovation, consumer welfare, you name it, but it is to encourage competition in terms of price, quality, innovation. All right, what are the kind of agreements that will get you into trouble? And you means anybody, not just the chapters, but anybody. Think about our chapters here. When I think about our chapters and I look at the kinds of agreements, I'm looking at that horizontal agreement box, competitor to competitor. That's the box where if you end up having an agreement over cocktails or over beer at a chapter meeting and you start talking about shutting someone else out from competition, that could land you, potentially, frankly, could land you in jail. Let's be honest about it. There are criminal penalties that come up to the antitrust laws, and that is the sort of thing that sends you away. You don't want to do that. And obviously as an individual, but also for the success of your business. It is okay to be talking about general things in the industry that may help all, but it has to be, as they say, for the good of the order. It has to be for the good of everyone, not just for the good of your business. And so things like price fixing, agreements on production and sales volume, market sharing and partitioning is what I was just referring to. Hey, we'll bid on these, and even if it wasn't, you know, even if it wasn't an agreement to shut someone out, but if it's an agreement just to only include people like you or companies like yours, then that could potentially get you into an issue. And where I've seen before is I'm gonna now do a little bit of an overlap between antitrust law and the issue of membership restrictions. And what I've seen from time to time is that sometimes a chapter may say, well, you know, we don't want to, and I'm not referring to any chapter in particular here, just to be clear about that, but we want to exclude company XYZ contractors because we don't like them, because they don't do business the way that we think they ought to do business. They don't, you know, they just don't, and you know, you can imagine what somebody might say about a competitor. They don't have the right integrity. They haven't been here that long, or they're new to our area. We don't know who they are. Those are the kind of things that could potentially get you in trouble, because just not liking your competitor is not enough reason to say you can't join the chapter. And that could end up with an allegation of that market share and partitioning of the marketplace. And of course, bid rigging, I would hope that would go, you know, unsaid, that you don't need to, no communications about bids. Another organization, not the IEC, that I'm involved in, has a social every month, that they make sure that the social is done after bids are announced, after the bid packages are open, so that we don't run into the problem of the beer opening up the conversation, to put it lightly, as one of my friends in that group said. What agreement means is interpreted very widely. So wink and a nod type things, whether it's informal, oral, something that's not legal. It doesn't even have to be in a contract or written agreement. It doesn't even have to be on the back of a cocktail napkin. And so what you want to do is you just want to be very, very careful and make sure that you are not engaging in these sorts of things. And I like to see it. I know that the National has an antitrust statement. I don't know if you individually, chapters have developed your own, but you should. It's not difficult, and in fact, I think I have one, so if you want me to email one out to you guys, and I can provide this up to National, or frankly use Nationals. I think it's pretty good too. And I say that without having looked at it today, but it is I looked at it at our last safety committee meeting, and it's pretty good. It covers these topics, and I think that I don't think our friends at National wouldn't mind you incorporating it into your own practices. I hope you already have one, because of the ramifications could be severe, and we don't want any of our members or chapters getting into that trouble. All right, so let's go on. Keep going. Trade associations. Couple of pointers here that we need to take a look at the law and see what happened, what has happened. Discussing generic issues like competitive parameters, discussing generic issues like environment, taxes. All those things are fine. But getting into competitive parameters, and that's going to be pricing, volume, bid details, those sorts of things, those are ones that we don't want our members discussing. All right. Dealing with competitors, these are the do not discusses. This is your punch list of things not to be discussed. So as you peruse that, I'm actually going to have to switch off my headset because it just told me that it is low on battery. So pause me for just 1 second, and then I will resume. All right, I'm back. Okay, back with you. Sorry about that. All right, so dealing with competitors, as you'll see on this slide, prices, discounts, timing and prices, intended bids, strategic or marketing plans, capacity, supply terms, outputs. All these are what you would call those competitive parameters. Those are things that you want to stay away from and avoid those discussions. Now, before I get into the employment law issues and use that as, and that'll be sort of the wrap up as we hit the last 10 minutes here, I do want to talk about apprenticeship programs briefly. I don't have any slides on this issue, but I do want to just emphasize across the board how important it is to make sure that your apprenticeship programs are in good shape. And what I mean by that is twofold. Number one is what I've seen over the years is that part of our biggest value proposition for our members from the chapter perspective is the provision of a high quality apprenticeship program. And so the members have come to, I certainly know here in Tampa Bay, it is outstanding, it is well known. It is a value problem. It is how we get new members, new contractor members, is to have a very good apprenticeship program. There is paperwork to be done, both at the state and federal level, and I cannot say, and I don't want to hold out to you that I am an expert on apprenticeship programs. My colleague in our D.C. office, Al Robinson, is outstanding, and he was the assistant, one of the assistant directors of the Department of Labor Wage and Hour Division for a while. Actually, he was an interim director. I'm messing up his title, but Al used to be a big wig with the Department of Labor, put it that way. Al's a genius. He knows it well. So if you have any issues with your apprenticeship program, let me know, and I'll get you in touch with Al. But it is critical, and I cannot emphasize this enough, to make sure that you are dotting your I's and crossing your T's on your apprenticeship program. It goes to that core issue in the beginning of the slides when we talked about 501c6. It is one of the best benefits we provide to members that benefits everyone, and it's available to everyone. And we want to make sure that we have done that and done that well. There are also some changes coming up in apprenticeship programs. I don't know if any of you bothered to take time to read the what's called the skinny budget that was put up by the Trump administration, but if you look under the Department of Labor section, it talks about increasing the encouragement of apprenticeship programs. Nobody knows what that means right now. And until we get Acosta confirmed as the Secretary of the Department of Labor, nobody's going to know what that means. And I'm assuming that Mr. Acosta is going to get confirmed. That's kind of the feeling and the expectation right now. But assuming that occurs, we'll start seeing some leadership put in place, and over the next few months, we'll know more. But right now, I think we can see, at least from the White House's perspective, there's an expectation of an increase. I don't know if an increase in funding, but an increase in emphasis for apprenticeship programs, and we want to be front and center to be able to say that we have outstanding programs that comply with all the requirements. So it's not only a matter of what is the value proposition, but it's also being, for our members and new members and prospective members, but it's also a tremendous issue when it comes to, what may be coming next from the Trump administration. All right, employment law. Last 7 or 8 minutes here to go. Employment law compliance. Thou shalt not discriminate, harass, retaliate, fire whistleblowers, and mess up your pay issues. That's it. Employment law 101 in a nutshell. Tongue-in-cheek, of course. Employment law, really, I'm going to be honest with you, even though I've been doing this 22 years, is not that difficult. And why I say that is because at the end of the day, for the most part, and this is not an exclusive rule across the board, but for the most part, if you treat your folks with dignity and respect, they'll work hard for you, you'll get good work out of them, and things will go well. Be mindful of inadvertent things, because there are law firms out there that will come after you because you inadvertently failed to comply with something you are not aware of. And I'm going to direct you in particular not to the discrimination, harassment, retaliation piece. Frankly, that's easier to understand. I'm going to talk about the pay issues. The Fair Labor Standards Act is a federal law that says all businesses, all employers must pay minimum wage and overtime over 40 unless the positions are exempt. That is your single number one biggest way to get sued as an employer, whether you are a chapter, a contractor, a janitorial service company, or a law firm. It is the number one way to get sued anywhere in America. So you want to be careful, and you want to make sure that you have dotted your I's and crossed your T's there, because although I say on this slide 15 employees is the usual minimum for coverage, that is not true under the Fair Labor Standards Act. You can have one employee and run into coverage and trouble with that law. So you want to make sure, and here's a final checklist item, and I'm not going to tell you to go review every employment policy you have, but I would encourage you to review very strongly your pay practices. And here's how you do it. It's pretty easy. Get out your organizational chart. Take a look at who are your executives, who are your seniors. You have the executive director and whoever reports to the ED. Put it on an organizational chart. Now, I know our chapters are not major employers. We don't have dozens and dozens of employees, so can't be too difficult. But then I want to know on your table, I want to know who you pay on a salary basis. And then I want to know why. Because remember what I said, you have to have an exemption to be paid on a salary basis. You cannot just simply say, well, this person, we don't pay this person on a salary, or we don't pay this person by the hour, we pay him or her on a salary. Well, that doesn't finish answering the question. The question is why, and under what exemption are you claiming? Is it the executive or supervisory exemption? Is it the administrative exemption, or something else? And you would be surprised at how narrow these exemptions can be. Now, you may have also noticed there was a whole lot of noise last year about the Obama administration trying to change the minimum threshold for the salary basis. That's true. That is now gone. There was an injunction entered, and the Trump administration is not going to pursue that. We don't know what ACOSTA is going to do, so that's another area where we'll find out in the next 3 to 6 months once we see who's going to be heading up the wage and hour division. But what I want you to do when it comes to that task, when you take a look at your organizational chart, is once you understand, or once you have circled those folks who you pay on a salary basis, you need to be absolutely certain about whether or not that is an appropriate exemption. Because if you are wrong, and the Morgan & Morgans of the world, and that is a law firm here in Florida, and they've expanded to other states, but the Morgan & Morgans of the world chase these lawsuits. They love them. I had to settle a case this morning for a very small client restaurant with only about 8 employees, and actually in this case it wasn't that firm. It was another one that's similar to them, and it was 80% of the payout is going to the law firm, not the employee. I don't know about you guys, but I'm horrified by that, and frankly, as a lawyer, somewhat embarrassed. But that's our profession. You don't want those knuckleheads trying to track you down and mess up your mission in the chapter. So among all the employment law issues, the one thing that is at the top of your list is making sure that you have pay correct. And if they're non-exempt employees, you're paying by the hour, your biggest issue is, do you have a system in place by which you can prove to the outside world that you are paying your employees for all time they work for the chapter? And that includes, and here are the big issues with chapters. Do you give hourly employees, non-exempt hourly employees, a cell phone to use? And are you calling them after hours? Are you tracking that time? Are you paying for that time? Are you paying them for time during the day? What about time to attending conferences? Lots of questions I've seen come up over the years with chapters, so you want to make sure that you're paying folks for all the time that they're working for it. But the biggest issue, make sure your exemptions are proper. All right, that's my soapbox on employment law, and I didn't see any other questions come in, I don't think. So we're about 2 minutes to go, I think, until the top of the hour by my clock. And I think I've touched on everything. Tim, I know you guys are listening in. Is there anything else you'd like me to hit on in the last 2 minutes?
I did it. No, that sounds good.
Can everyone hear us, or
Yeah,
just Phillip?
yeah, you're on.
I can hear you, Tim.
I think, Phillip, if maybe you could just touch on briefly, just from a 30,000-foot level, on just the importance of when a chapter or an organization runs an apprenticeship program, either with the state or the federal government, Department of Labor through the Apprenticeship Bureau, that there needs to be constant oversight, and it's something that when we have this type of webinar or seminar, we talk about that in general terms to our chapters.
Yeah, and earlier I spoke a few minutes about that, but yeah, that compliance, I think the critical importance there is really reflected in two things. It really is that value proposition out to the public in terms of our members, but also prospective members. But also it is that we don't know what changes are coming, and the programs, the changes are coming, I think, are going to be good, but there's still going to be limited resources, and you want to be the shiny example. You don't want to be the apprenticeship program that has compliance issues, even if they're administrative compliance issues. You don't want to have that on your record, because there are some good changes that are coming, and you want to be standing in the front of the line, so to speak, when it comes to getting what those new benefits may be.
You may want to put your screen back to the slides too, Phillip.
Oh, sorry.
We're looking at your emails. We get enough of our own emails. I don't think we want to answer any.
I'd be happy to put them back up there if you would just answer the emails for me. So action items here, a few items just to wrap it up. Are you covered under the employment laws? By which laws? Do you have or need EPLI? And this is the action items for the employment stuff. Training for your ED and management team, and then reviewing your enforcement program. But the most important thing I could recommend for you is do that organizational chart and take a look and see if you've got any issues on exemptions or tracking time. Any other questions come in, guys?
Well, I don't see any more questions at this time. This is Dresden again. Phillip, thank you so much for such a thorough presentation. It was absolutely outstanding. With my role now at IEC, again, new Vice President of Chapter Development, I just want to let everyone who participated today know that I'm always here to help as you sort through any of these issues that you're having, particularly if you are a new ED. I have training and expertise in this area, and I'm always here to help. So again, thank you so much, Phillip. I want to let everyone know that our next webinar is April 12th at 2 p.m. Eastern, title being Looking Past the Skills Gap Crutch, How Electrical Contractors Can Market and Recruit Talent in Today's Challenging World. So I hope all of you can join us for that then. Thank you so much, everyone, and have a good week. Thank you.
Thanks, Phillip.